All right, welcome back to Kivumbi 2017. Let's continue with our conversation here in studio. And gentlemen and lady, I want us to talk about the kind of responsibility that the Supreme Court now has. As Anthony earlier said that, Raila Odinga said that this is a chance for the Supreme Court to redeem itself from what happened back in 2013. Dr. Conrad, what kind of a burden does David Maraga have on this one?
Speaking of the Supreme Court, and I think going back to Raila's statement about redeeming itself, one thing that I think the Supreme Court might want to bear in mind is possibly the mistakes. My personal opinion is that I have read the judgment of 2013 and the finding of the court, and there were deep flaws in that judgment. You read through it, what this court sets out to rule in the judgment and the conclusions, they're just totally different. Secondly, and I think the most important thing is that in that judgment, technicalities triumphed over substantive justice. So I think the Supreme Court, headed by the Chief Justice and the other judges, have a duty to ensure that this time justice is served, so that whichever, we don't know the kind of evidence that will be ventilated in court, but we hope that as they claim, they will have evidence to substantiate that what was announced by the IEBC is not a reflection of what the voters did around the country. And of course, then the NASA lawyers will have to present evidence to show that maybe there is inconsistencies between what was transmitted electronically and even a representative sample of Form 34As and Form 34B to show that. And there are two things, I think, in terms of determining the result. One, the court, looking at the whole process, will have to satisfy itself that IEBC delivered a credible, transparent, fair, and free election. And if it did not, whether the flaws actually are so irredeemable as to cancel the result. So that is the burden that the lawyers have and the courts to see whether that threshold has been met.
All right. And talking about lessons, what lessons, Charles, do you think that the legal team and even, the judges should take from the 2013 petition?
There is a lot of lessons to learn, and there are also a lot of things that the NASA legal team should really consider more important. And going back to the opportunity that the Supreme Court is having, I believe that a majority of the bench there are people who have had very successful careers, first of all as practitioners, so they really know the very essence of litigation. One thing that the lesson that the Supreme Court should learn, they should now depart, a complete departure from focusing on the technicalities. The last bench in 2013 really considered itself much about technicalities, this affidavit, filing out of time, coming late. So those are more procedural issues that our constitution has said that justice should not be denied based on procedural technicalities, that you did not serve this, you did not put this together in the first instance, therefore we are not admitting this kind of evidence. If that evidence was so crucial and so central to the matter to be litigated upon, then the courts have its own powers to ensure that such evidence is listened to and it is admitted. To the NASA legal team, I would still persuade them very, very strongly and respectfully that let the issues that they are going to present before the court be very, very few and focus to the point. The moment they open themselves to a lot of technological issues, if in any event there could be technological failure, how did that failure fundamentally affected the overall presidential results? The moment they would be able to distinguish and get that this is the thing that we want to discuss in terms of technology. Because cyber law, technological issues, there are so much many that even the advanced nation have not finally developed a mechanism and even laws to address the issues of technological challenges in terms of cybercrime, hacking. So I would really persuade that the legal team don't delve much into those cyber things and technological, but now narrow down how could this affected the final tally.
Okay.
Because in any event that you want to challenge, and now they are already dancing, because if they see the commission, once they had made that administrative decision and they have declared results, they do not have any business even to come back and tell Kenyans openly there is certain things that are still missing.
All right.
They should have been put in place, and the Supreme Court has a duty to ensure that justice is served. And it's not only served, but it is seen to be done.
Okay.
So that the Kenyans can be happy and no issues will be raised with that decision, somebody trying to revise it, somebody trying to challenge or set it aside, those 2013 decisions. So I think if they can consider all those kind of things, then I think they would be good to go.
They'll be good to go.
Yes.
All right, Stephanie, let's also talk about the independence of the judiciary. Even, weeks into the election, and David Maraga was one troubled man because he was all of us saying that, do not attack, the judiciary because, all manner of leaders, right from the Jubilee to NASA, at some point they're casting allegations that are negative against the judiciary. But here comes David Maraga saying that the judiciary is independent and they will be working, within the law to deliver results that are indeed credible and fair. What kind of responsibility does the Supreme Court now have? Just looking into all these issues that have been raised against them by the same leaders, some of who are also just moving to the courts right now.
I feel like it is up to the judiciary now to live up to their statements. They've been giving us a lot of PR. They tell us we'll be independent, we'll be all that. But they have to realize that all of us are watching. Kenyans are watching. Systems have failed us. Leave alone. So we're waiting on the judiciary to at least give us some hope. So with regards to that, I feel like they need to, and this is what I was telling Anthony, that it was not intimidation, it was more of a warning and maybe some form of encouragement. Because honestly, we all know the judiciary has not been the best. Leave alone this presidential has not been the best in some cases. Leave alone this presidential petitions. Even looking at the local context, cases take so much time, there's so much backlog, there's so much issues with the judiciary. And now we are looking at them to get rid of all this, ensures that they can be able to do their work. And we are all looking to them because we do not know what evidence NASA has from the clouds. We are waiting for it to descend. So our eyes are all on the judiciary to interpret this for us and lead us in the right direction.
All right. And Anthony, how will we as Kenyans know that the judiciary has given us the best result after the 14 days? Is it about, if I was supporting Uhuru Kenyatta, if the Supreme Court rules against that petition, then okay, the judiciary is working and it's independent, or vice versa? How will it come out and how will Kenyans really ascertain the independence of this institution?
I think it all depends on how it will be handled this time round. And the burden for them is really heavy because when you're the court of first instance and yet you're the final stop, then you have to be extra judicious. And therefore, I think what should happen after the filing of documents and serving of the responses, at the pre-trial conference, which should be public, if you ask, the court should ask the parties, what are the issues you want us to decide?
Okay.
Because last time it was not clear what were the main issues.
Yes. Yeah.
So it should be very clear. These are the issues that have been placed upon us to decide. And therefore, that decision must then address those issues that will be framed at that pre-trial conference. Then again, I think the tragedy last time was, again, because of the timelines. You say, we are dismissing this petition, but we'll give you our reasons later. I think that is where all suspicion started. I'm not sure that within those 14 days you can write a reasoned judgment. It may be possible if you burn the midnight oil. But I think they must really make sure there's no cause for suspicion, like what happened last time. And I think beyond the technicalities also, that delay in the main judgment also raised some eyebrows.
It raises some issues. You want to add on that?
Yeah, I want to say something about now that it's the question which was raised about the independence of the judiciary and its ability to rule effectively especially on the presidential election petition. First of all, I think after the 2010 constitution, we saw massive reforms in the judiciary. There was a comprehensive framework to reform the judiciary. And I think, in my view, on an overall assessment of the performance of the judiciary, I think it's one of the arms of government that has really tried to live up to its its constitutional mandate. It has clashed with the executive several times. It has clashed with the Senate, the National Assembly, as a result of decisions which it has tried to make and asserted its independence. But where we see the challenge with the judiciary is where we have the presidential election petition, because that's when the judiciary comes under a lot of intense political pressure, even Raila's statement. But I think it's important to mention here that we must recognize the judiciary and its limits.
Okay.
You know, we cannot mess up an election process. We mess up the politics in this country, and then we expect a single institution to clean up all that.
All right.
Yeah. So I think it's very important that in the long term we get our institutions, our processes, and everything right, so that then the judiciary is able to deal with jurisprudential issues which emerge from all those cases. For instance, the judiciary does not conduct the elections. It's up to political parties, it's up to the IBC and us, the people, to support a fair and credible process, and then the judiciary can come in to address the legal issues. For me right now, I feel sometimes presidential election petitions put a lot of burden on the judiciary, sometimes which they are not able to dispense.
That.
But
all right, very briefly, Charles.
Very briefly on the concept of judicial independence. I think the concept of judicial independence has been a very elusive one in our context. And more importantly, if you look at all these three arms of government, they are not completely detached. That the independence, that one is very, very independent. And independence should not be a perceived one. In regards to judiciary, there should be that actual independence. Because the moment you want to cast aspersion or doubt or conduct a judicial process in a manner that would make someone believe that because of some political pronouncement, I've actually made the judges, these are human beings. And we must talk about that judicial independence together with what we call judicial activism. Judicial activism is a concept whereby decision of the judges are influenced purely and entirely with their also personal philosophies of life. Because we should also not forget that these judges are also human beings. But the moment they allow that being a human being thing to influence their decision, then that independence will only be just a perceived independence, but not an actual judicial independence, which should be the case.
All right. We'll move the conversation forward and talk about governors who are now assuming office. But